Welcome to Vishnu Consultants. Today we will learn about trademark, brand name and logo. A trademark is a unique identity that differentiates your product or service with that of others in the market. It can be a unique word, name, logo, numeral or any other distinctive identifier. It is essentially a representation of the owner's company, name, brand or logo and can be a combination of all these things. A registered trademark is an invaluable asset to your company as it is used to protect your company's brand. Registration ensures protection of your unique name, logo and brand by restricting usage by other competitors as identical or similar marks cannot be registered. Trademark owners have the right to use their mark exclusively for a period of 10 years from the date of registration. The process of trademark registration passes through some steps or stages. Let's discuss the various steps and stages and what are they. With the advancement of technology, now you can apply for trademark registration through online. You can file your application yourself or may engage a trademark attorney. The application can be filed online in the web portal without making any effort to visit the office physically. The first step is Trademark Search. Before you decide to register your trade name or brand name or logo, it is necessary that you must search for availability of your proposed trademark, brand name or logo. Trademark Search will help in providing information about identical or similar trademarks already registered or filed with the trademark authorities for registration. There are a total of 45 classes in Indian Trademark Act 1999. The first 34 classes, that is from class 1 to 34, are for goods and rest of 11 classes are for 35. From 35 to 45 are for services. A keyword needs to be searched based on the nature of business and business activity in the relevant class. Engaging those consultants who have expertise in effectively performing such searches with the keyword yields desired result within the set time span and saves time and money for filing the application for registration of the desired mark. The keyword search may be for a logo, word, combination of word, design, a name, number or any other unique identification symbol and for identifying a product or service. Nowadays, many agents are conducting trademark search for their clients free of cost for 2 or 3 marks and thereafter for a nominal charge. The agents have expertise in searching the mark to ensure that the chances of acceptance of the applied mark are good and they help their client in investing, coining, phrasing and designing the mark inherently distinctive and capable of identifying and distinguishing itself from that of the already registered marks of their business competitors in the marketplace based on the business activity of the proposed goods or services. It avoids litigation and infringement of the already registered same or similar distinctive conflicting marks, thereby helping the clients in reducing the valuable time and money of all the concerned and in replying to the objections and oppositions, if any, raised by the Trademarks Authority and the registered owners. The second step is application filing for registration. After you have completed your trademark search, you might have gained knowledge and information about availability of names and the class in which you need to file the application. Filing the application in irrelevant class leads to its rejection. By now, you might have also decided the name for your brand name for registration. An application in prescribed manner need to be filed along with the requisite fees and with trademark registrar. An application in prescribed manner needs to be filled along with the requisite fees with the trademark registrar. The following documents and information are required for filing trademark, brand name, logo application. Have a look. The applicant himself or herself can file the application for trademark registration by using his or her digital signature obtained from a licensed certifying authority and downloaded into an USB crypto token. However, in normal practice, the applicant engages the services of a registered trademark attorney. The applicant needs to provide authorization to his agent in Form TM 48 of the Trademarks Act 1999. under Section 145 Rule 21 for applying for the trademark registration on his behalf by revoking all his previous authorizations, if any, in respect of trademarks and or service marks made by him earlier, and with an undertaking to ratify and confirm whatsoever his agent shall lawfully do or cause to be done by virtue of his current form, Trademark 48, such an authorization remains active and valid until and unless the applicant revokes it and authorizes some other agent. The third step is the Vienna codification process. After the application is filed for registration, the trademark registrar will apply the Vienna classification as established by the Vienna Agreement, and the application will be put in process, and the trademark application status usually reflect as sent for Vienna codification. The fourth step is trademark examination. After completion of Vienna codification, the trademark application attains the status of formalities check pass, and it will get allotted to an officer in the trademark registrar office. The office will then review the trademark application for its correctness for the business activity, class in which the application is made, etc., and issues the trademark examination report. The process may take somewhere between 4 to 5 weeks after filing of the application. The officer may accept the trademark application as it is or object the registration process. If the application is accepted, the registrar allows it publishing in the Trademark Journal. If there is any objection, the registrar raises an objection and issues an examination report under the provisions of Trademark Act 1999 and the Trademark Rules 2017 and stalls the registration process. The examination report contains all the observations and details the reason for such objection and the section under which the objection was raised, and the registration process was stalled. In such a case, the applicant is given an opportunity to submit reply to the objection raised in the examination report within 30 days from the date of issue of the examination report, and the content of the report are self-explanatory. A copy of the report is also displayed on the official website of the registry. Have a look at the most common objection raised under these sections. Now let us look at some of the major reasons for rejection of trademark application. A registered trademark can help the trademark owner and prevents unauthorized use of the mark and creates a valuable intangible asset for the company. However, the trademark registration process is long, typically taking anywhere between 12 to 18 months to know the final status of an objected or opposed trademark application. Since the process takes such a long time, many businesses begin building a brand around the mark while the trademark application is still pending. If the trademark application is finally approved and the mark is registered, then the efforts spent on brand building is protected. However, if for some reason if the mark is not registered, then there is a likelihood for the brand to be under threat. Hence, we need to look at some of the major reasons why the trademark application is rejected so that these mistakes can be avoided while choosing a business name or trade name. Commonly used words or terms that are usually found in dictionaries cannot be trademarked. Words that are commonly used to describe a product can also not be trademarked, as it would be considered a descriptive term. Also, qualitative or praise terms such as rapid, best, classic, or innovative terms cannot be trademarked, unless it is a part of an otherwise distinctive mark. Deceptive trademarks are marks that may deceive or mislead consumers as to the nature, quality, or geographical origin of the product. Trademarks that contain offensive terms or words that are contrary to public order or morality cannot be registered. Also, words and marks that are considered to be offensive or violative commonly accepted norms. Many trademark applications are rejected because they could be in conflict with an existing trademark. Having two identical trademarks is contrary to the intellectual property rules and would cause confusion among consumers. Hence, any trademark that is similar or could potentially be confused with an existing trademark would not be registered. Trademarks that contain official names, flag, bearings, official hallmarks, and emblems of states and international organizations cannot be trademarked, as they contain elements that are protected under national regulation. How to choose a business name? To improve the chances of choosing a business name that can be trademarked, follow the below checklist. Ensure that the mark does not fall under any of the categories listed above. Perform a trademark search to ensure there are no similar trademarks. Perform a domain name search to ensure that the domain is available for the mark to avoid any cyber squatting in the future. Now, if you are still doubtful, get consultation from a trademark registration expert. When the trademark registrar accepts the application for registration, the proposed mark would be published in the Trademark Journal. This journal is published weekly on every Monday and includes all the marks that registrar has accepted during the week. After submission of the application for trademark registration, the applicant or his agent can periodically check status of the application in the trademark web portal. After the mark is published in the journal, already registered trademark owners can oppose the application under reference if they think the said application can damage the business. Some of the reasons cited for such opposition could be identical or similar name or description or color or phonetic similarity, etc. However, if there is no opposition from anyone after completion of 120 days of publication of the mark in the Trademark Journal, the registrar allows the mark for registration and starts the process for issuing the registration certificate. Normally, the certificate is issued in the next week of its final acceptance by the registrar. In other words, if everything goes well in normal circumstances and without having any objections raised by the registrar and without any oppositions from the public, the registration certificate would be issued by the registrar approximately in 6 months' time from the date of submission of application in the prescribed form. In case the application faces opposition from a third party, the applicant will be informed accordingly. The registrar issues a notice of opposition in the prescribed form giving name and address of the opposite party and the reasons for such opposition. Again, this gives an opportunity to the applicant and he needs to oppose and contest the opposition by submitting reasons for his application, along with documentary evidence in support in respect of his claim for registration of his application. If the trademark registrar is not satisfied with the reply submitted by the applicant in response to the letter of opposition, a hearing would be fixed by the trademark hearing officer for hearing arguments of both the applicant and the opposed party. Both the parties have the right to be heard by appearing before the hearing bench and to provide their side of justification respectively, based on the arguments and the documentary evidence submitted by the parties. The trademark hearing officer will determine if the application should be accepted or rejected. However, the decision by the hearing officer can also be challenged by appealing in the higher judiciary. If there are no objections or opposition, the trademark manuscript and trademark registration will be prepared and registration certificate is issued. The registration certificate contains all the details such as name and address of the owner, nature of business, class in which the mark is registered, the logo, etc. After issuing of the certificate, the mark is considered to be the registered one, and the owner of the mark is granted with exclusive rights of the mark. The registered trademark owner can use the R symbol in the circle with the mark. Such registered mark, be it a trademark brand name, word mark, logo, is valid for a period of 10 years. After its expiry, the mark can be renewed for a further period by making an application to the registrar's office for renewal in the prescribed form and by making the requisite fees applicable at that time. This content is a part of our knowledge sharing series for educational purpose. Do you have any questions or you need any clarifications? Comment down below. Thank you. For more such educational content, subscribe to Vishnu Consultants.